Okay, guys, so here we are in the next chapter talking about civil rights and the push for equality of all citizens in with primarily political rights that make it possible to participate in society. And civil rights, you see there, the definition of civil rights, the central rights necessary to ensure full participation in the political and civil life of a society. So, whereas civil liberties are things like freedom of speech and freedom of religion, civil rights are things that have to do with participation in government. The right to vote, the right to serve on a jury, the protection of equal treatment by the government, etc. Okay, so we start off with suppose the most fundamental right of all of those is the right to vote. We are a republic after all, and therefore to be part of a republic, to be a member of a republic, means to have the ability to participate in decision-making. Most importantly, choosing those representatives who will be running the government for you. Okay, so the right to vote we also call suffrage. You hear the term sometimes universal suffrage, meaning everybody having the right to vote, as opposed to universal male suffrage, all males having the right to vote, or restricted suffrage. Initially, we know back from the time of the American Revolution, voting rights were restricted to adult, free, that is non-slave, property-owning males. And that's a tradition that goes back to Great Britain. To be eligible to vote in England, back at the time of the Revolution, they had a parliament, they had a representative parliament. But in order to vote, you had to be male, you had to be an adult, and you had to own a certain amount of property. That was considered acceptable. If you were a property owner, you had a stake in the community, you were paying taxes, you were to that extent helping to pay for and responsible for the government, and therefore you had a voice in it. The property requirement, how much you had to own in order to participate, varied. In England, it was so restrictive that 1 in 25 people actually had the ability to vote. In the colonies over here, there were property requirements, but they were wide enough that the majority of adult males actually could meet the property requirement that allowed them to vote. When the United States declared its independence, we became our own separate country. The states opened up the franchise. Franchise, another word for ability to vote. Property requirements were reduced or dropped altogether. There were still property requirements in some states as late as the 1850s, but in fact, most states were dropping them from the 1700s through the early 1800s. At the same time property requirements were being dropped, northern states were abolishing slavery, and you didn't have, how do I put this? Slavery was a legal issue, but color of skin was not necessarily. So if you were a non-slave in the northern states, you actually had the ability to vote in 5 out of the 13 states. The southern states, no. If you were black, you were a slave, and if you were a slave, you were black, and even free blacks, which were very hard to come by in the southern states, didn't have the right to vote. But in New York, for instance, or Massachusetts or Pennsylvania, if you were not a slave, an adult black man, had the ability to vote, presuming he met whatever property requirement there was at the time. I'll tell you this too. Women actually had the right to vote briefly in New Jersey. When New Jersey passed its first state constitution, before the federal constitution was passed, it gave the right to vote to adult property owners, and it made no reference to sex. There was no reference to gender. So women actually were permitted to vote for a brief time until in the early 1800s they amended that and took that away. Okay, so adult white males are allowed to vote. Blacks who are not slaves in some states could vote, but you still had slavery that was permitted in the country. Under the Constitution, as you know, Constitution goes into effect in 1788. It was written so that 20 years after the Constitution, 1808, the slave trade would be banned. So the South kept slavery, that was still in the Constitution, but the North got a concession from the South. They couldn't import into the country any more slaves after 1808, which doesn't really matter because the slaves, were having children and so were multiplying without having to import them. So the South was not terribly worried about that. Even though the slave trade is banned, and some of the states like Massachusetts have done away with slavery, Pennsylvania has done away with slavery by then, New York would completely get rid of slavery by 1820. Slavery certainly persists in the South. And blacks effectively have no right to vote. We remember from U.S. history the Missouri Compromise of 1820. The Missouri Compromise solidifies slavery, but it also solidifies abolitionism. So under the Missouri Compromise, we remember, the new states that were being admitted to the Union out of the Louisiana Purchase territory, the northern part of that Louisiana Purchase territory, the new states were going to be non-slave. The southern part would be slave, and Missouri would be, the new state of Missouri would go slave. That was the way to keep, if you will, the number of slave states and the number of free states even, as a way that they kept trying to delay what was inevitably going to be the Civil War. So it solidifies slavery in the South and increases the number of slave states, but it also increases the number of non-slave states in the North and kind of solidifies the country into two halves, the pro-slave and the abolitionist half. As a result of that, the American Anti-Slavery Association gets started, 1833. And even though the American Anti-Slavery Association is obviously about slavery, it's an abolitionist group, it is largely driven by women. Again, as you know from U.S. history, it is women, particularly women of a particular religious background. The northern, they saw this as slavery as an affront to humanity, and to the image of God in each human being, that sort of thing. And so these women were in many ways the driving force behind the anti-slavery movement. And so the anti-slavery movement and the movement for giving women more of a voice in the country get all tied up with one another. The fact that women are sidelined by a lot of the restrictions on their ability to vote. Women could not vote. Women could not serve on a jury. Women didn't have the same rights in court that men did. was inhibiting their abolitionist activities, and so it began to make them think about women's rights. So Elizabeth Cady Stanton and Lucretia Mott, as you remember from U.S. history, really start off in the anti-slavery movement, but the Seneca Falls Convention, which begins the women's rights movement, really grows out of that. Now, once again, guys, I am assuming that you are reading the book carefully and intensely, and I'm assuming that you remember this from U.S. history, so I don't have to spend a lot of time on it. 1850s, of course, you have the publication of Uncle Tom's Cabin, which is it popularizes, if you will, a horror of slavery. Harriet Beecher Stowe, who wrote the book. First of all, it's not a coincidence that she was the sister of Henry Ward Beecher. Henry Ward Beecher was one of the most famous Protestant preachers and religious figures in North America at the time, and was a screaming anti-slavery guy. He worked out of Brooklyn. He had a church in Brooklyn that became one of the great centers for the anti-slavery movement. His sister, Harriet Beecher Stowe, wrote Uncle Tom's Cabin, which of course galvanized the North with its depictions of how dehumanizing and heartrending slavery could really be. And so, the abolitionist forces begin to pick up steam, and then that gets us to the Dred Scott decision. Now, I'm sure you remember the Dred Scott decision from U.S. history. I just want to therefore review it briefly. The Dred Scott decision, first of all, is a rather complicated decision. It has a very simple outcome, which is, in the words of the Chief Justice who wrote the decision, who was Roger B. Taney, or Taney, T-A-N-E-Y, although the family pronounces it Taney. Roger Taney wrote famously that no black man has any rights that any white man need respect. Black people, by the fact they are black, according to Roger Taney, have zero human rights. That's, of course, the famous outcome of the case. The legal reasoning in the case was somewhat more complicated. So I just point this out to you. The Supreme Court, when they took the Dred Scott case, first had to decide whether or not it was a federal case. Dred Scott, as you know, had been a slave. His family that he had been, quote, owned by, took him to Minnesota, which is a free state, and then had taken him back to Missouri, which is a slave state. And he argued, and I'm way oversimplifying this, but if you remember the case, you know I'm oversimplifying. If not, you can go read it for yourself. Dred Scott argued that because he had been taken out of slave territory into free territory, at that moment he had become free, and therefore was a citizen of another state, and had his freedom, so that when he was taken back to Missouri, he should have been counted as a free man at that point. Scott claims that the federal government should intervene in this because he, Scott, is a citizen of Missouri, and Sanford, who was the family that wound up sort of inheriting him, they were citizens of New York. Under the Constitution, the Supreme Court cannot simply decide any case it feels like. You have to have a federal reason why it's in federal court rather than a state court. One reason could be a federal law. Another reason is diversity of jurisdiction. What that means is citizens of one state suing citizens of another state. If citizens of New York are suing citizens of New Jersey, you have a problem. Which court do they go to get their problem straightened out? Then the federal government, federal courts can step in. So Scott said, well, I'm a citizen of Missouri, this guy's a citizen of New York, therefore citizens of different states, therefore federal case. The Supreme Court found, first of all, no. Blacks, that should be, let me correct that. They found that blacks couldn't be citizens of the United States. And therefore, if you're not a citizen of the United States, you can't be a citizen of any particular state. Tawney spends a good 20 pages of his decision discussing why a black person is not ever a citizen. Not everybody agreed with it. There was a dissenting opinion that was filed by one of the justices in the case who pointed out that in 5 states, when the Constitution was signed, blacks could vote and therefore were presumably citizens. But Tawney held that from the beginning of the United States, blacks were never considered citizens and therefore not citizens of different states. Therefore, a non-citizen cannot bring a lawsuit, and they're not citizens of different states, so it wouldn't be a federal lawsuit anyway, and therefore the court has no jurisdiction at all over the case. Second thing they found was that the Missouri Compromise was unconstitutional. According to Tawney, Congress cannot make a law that binds the internal affairs of an individual state. So the Missouri Compromise, Congress had made a law saying that new states that are formed in Louisiana Purchase had to follow this pattern. If they were North, they had to be non-slave. If they were South, they had to be slave. But, says Tawney, the Constitution doesn't give the Congress the right to make internal laws for a state. That would violate federalism, that principle of the Constitution. Therefore, Congress couldn't make a law telling Minnesota that it had to be free, etc. And therefore, the whole Missouri Compromise was an unconstitutional law. They also found that the Fifth Amendment prohibition against depriving people of their property without due process was being violated here. Remember I talked about that previously, eminent domain? The government can take property, but they have to follow a legal procedure and they have to pay you for it. A law that would simply free a slave, Roger Tawney claims, and he wrote the majority opinion of the court, would be taking property away from a property owner, that is, the slave owner, without giving them compensation, without paying them for it. And finally, they said, because it's not a federal case, it isn't properly a federal case, we have to defer to whatever the Missouri State Court said, and the Missouri State Court found that Dred Scott was indeed still a slave. Therefore, Dred Scott was considered a slave, and the Dred Scott decision basically, as you know from U.S. history, its importance is that it found that you had no rights simply based on the color of your skin, that there was no such thing as a black with civil rights before the law. Which, of course, is going to set us up for the Civil War. The Civil War, of course, we fight the Civil War, and etc. The Emancipation Proclamation during the Civil War, everybody remembers, freed the slaves, hooray, hooray. Well, it didn't actually, and it didn't really do that. I don't even list it here. The Emancipation Proclamation was a military action. Lincoln was saying that slaves were indeed property, but because it was property that had been banned for possession, it was therefore, slaves were therefore contraband, and they could therefore be seized by the federal government, who could then free them. In other words, the Emancipation Proclamation did not really end slavery. What it said, although that was the effect of it, what it really said was, you Southerners, you're in rebellion. Therefore, you're not allowed to own, they could have made a law, you can't own a gun and you can't own ammunition. And if you're caught with a gun or ammunition, the federal government gets to confiscate it as contraband. Well, Lincoln said slaves count as contraband. So if a slave is found, the federal government takes possession of them, and then they can free them. It only applied to the parts of the South that were still in active rebellion against the North. And Lincoln really did it, as I'm sure you know from U.S. history, as a matter of military strategy. By doing that, he made the war about slavery so that France and England, that had wanted to help the South, and the South had no resources to be able to fight the Civil War. They needed help from England and France. England and France could help the South if it was a war about states' rights or something like that. The minute Lincoln issued the Emancipation Proclamation, it became a war about slavery, and England and France had both abolished slavery, and their people would not politically support a war in favor of slavery, so they wound up having to stay out of the war. The South doesn't get their resources, and the South inevitably collapses. What really ends slavery is not the Emancipation Proclamation. What really ends slavery is the 13th Amendment that you see there. Passed after the Civil War, the 13th Amendment is really the thing that we put into the Constitution that makes slavery unconstitutional, and therefore the slaves are all automatically free. The 14th Amendment, 13th, 14th, 15th, as you remember, are those Reconstruction Amendments. They occur right after the Civil War. 14th Amendment guarantees equal protection to all citizens of the United States, including black citizens. And it says it doesn't matter your previous condition of servitude. So the point of it is, and due process, and the 15th Amendment, enfranchising newly freed slaves. The point of 13, 14, and 15, if taken together, is there is no such thing as slavery anymore, and everybody in the country, regardless of color or whether they have ever been held as a slave before, is now equal before the law and has equal rights and equal protection as citizens. Of course, that only applied to males. I mean, black women were free from slavery now, but the 14th and 15th Amendments, the 15th Amendment in particular, did not give women the right to vote. It gave slaves the right to vote on the same terms that whites had them, which meant they had to be adults, which generally meant over 21, and they had to be male. So the black men actually got the vote before white women did. Now, as you know, the South was not really thrilled about ending slavery at all, but giving the blacks legal equality. The federal government passes the Civil Rights Act of 1875, which gives equal accommodation in public places to blacks and whites. So they had to be treated equally when it came to public spaces, public areas, streets, roads, railroad stations, and particularly government offices and buildings. And it gave the federal government the power to enforce that equal accommodation and to make sure that the federal government had the right to enforce that equal protection clause of the 14th Amendment. So if the states were treating blacks and whites legally differently, for instance, not allowing blacks to vote, the federal government had the power to step in and let them do that. Notice that's the Civil Rights Act of 1875. Well, you can pass a law, but that doesn't change people's hearts. And so the southern states passed what are called the Black Codes, which are those state laws that prohibited black men from voting, from serving on juries, and therefore, by the way, if a black man, what does that mean? If a black man is arrested for a crime, he's going to face an all-white jury because no blacks can serve on a jury, etc. The civil rights cases of 1883 were a handful of cases. They're usually talked about together. I think it was 5 of them altogether that went to the Supreme Court. They were people who had been arrested and tried for violating the Civil Rights Act. So they had separate accommodations in a theater, in a hotel, in a railroad station for black versus white. And so they were arrested under the Civil Rights Act of 1875. It says equal accommodation. They were tried, and the case went to the Supreme Court. Supreme Court upheld the Jim Crow system, as it was known. Jim Crow was a character, a black comedic character who showed up in stage presentations at the time. The Supreme Court basically said that while Congress can legislate for public spaces that come under federal jurisdiction, like a federal courthouse, it cannot legislate for private property. So if you own a theater, that's your own private business. The Supreme Court said you can discriminate against blacks. You can have it can be a whites-only theater. If you have a hotel, you can refuse to take black guests. That's what the civil rights cases did in the late 1800s. As a result, the black codes included things. Now, remember something. Voting is controlled by states. The federal government, if you read the Constitution again, guys, it says, for instance, that the members of the House of Representatives in the U.S. federal Congress are chosen in elections by the states, and the states set the requirements for voters in the state. So when you vote for a member of Congress, the only rule that the Constitution gives is the state rule has to be the rule it has for its most numerous house of the state legislature. So in New York State, we have the state Senate, the state assembly. Whatever rule New York State has for who's eligible to vote for assembly is the rule that New York State must use for the House of Representatives. But that can vary state to state. Now, in our own modern day, does it vary? Yes. Who's eligible to vote? Well, in one state, they can say you're eligible to vote if you've lived in the state for at least 30 days. In another state, they can say you're eligible to vote if you've lived in the state for at least 90 days. In another state, they can say you're eligible to vote if you lived in the state for at least 2 weeks, 14 days. That's up to the individual state. In some states, you get into a very controversial area now. In some states, you are allowed to vote if you were convicted of a crime. You are allowed to vote as long as you have finished serving your sentence. So once you've done your time, you're let out of jail, now you're allowed to vote again. In other states, if you have been convicted of a felony, a crime that puts you in jail for a year or more, you can never vote again. That's up to an individual state to decide. How a state does its registration. There are some states that will let you register online, and some that let you register, you have to go down in person and fill out a form. Again, that's up to the state. So what did the southern states do with this? Well, back in the 1800s, they put in a series of laws. For instance, the poll tax. So when you showed up to vote, you could vote as long as you paid a tax, a fee. Basically, you had to pay a fee in order to vote. And the fee was made high enough that the poor couldn't vote. And the vast majority of the poor in these southern states were blacks. They put in literacy tests. You were only allowed to vote if you could prove that you were literate, on the excuse that you had to be able to read the ballot correctly. Well, what's the literacy test? Okay, well, if a white guy walks in, the literacy test is, a guy sits behind the desk. Oh, I want to vote. I want to register to vote. Great. I have to take a literacy test. Spell cat. Black guy walks in. Spell chrysanthemum. Yeah? The grandfather clause could be used in a couple of ways. One was you were only allowed to vote if your grandfather had been able to vote. Well, in the 1870s, no slave's grandfather had been allowed to vote. So you were giving slaves the right to vote, but you were making sure that no slave actually had the right to vote. Later on, the grandfather clause was used with the literacy test. So you had to take the literacy test unless your grandfather had voted, in which case you were exempt from the literacy test. Well, guess what? Again, you're excluding really only African Americans from voting with that. So the South came up with all these clever little antics to, blacks were allowed to vote in theory, but in fact they put so many obstacles in the way, they made it effectively impossible. Okay, that then brings us up to, we get out of Reconstruction into what's sometimes called the Progressive Era, if you remember this from U.S. history. And you have sort of cases that bookended, Plessy, Ferguson, and Brown Board. So we talk about Plessy Ferguson first. Plessy v. Ferguson was a case in 1896, which was about railroads, which was a public area. And in the case, as you remember, the court found that, how do I say this? As you know, the Civil Rights Act of 1876 said that the public accommodations, you couldn't discriminate in public accommodations. Blacks and whites had to have the same. Plessy v. Ferguson found that as long as the accommodations are equal, it's okay to have them separate. So you could not exclude blacks completely from a railroad station, for instance, but you could have a separate railroad station or a separate room in the railroad station for white and black, as long as the accommodations are equal, to keep the races separate. Plessy v. Ferguson, again, like Dred Scott, another infamous decision. Well, as a result, in part, of Plessy Ferguson, groups like the National Association for the Advancement of Colored Persons, or colored people, really get juiced up. They get really launched. The NAACP's point is that separate is by definition unequal. That when you separate out the races like that, when you discriminate, when you treat them as if they are separate things, you are differentiating between the two, and that's not permitted. If we're equal under the law, then the law needs to be colorblind. And so if I can just skip down for a minute, the NAACP decided to pursue its strategy by using existing law to change society. There was a deliberate decision they made to, rather than change the law, to use the courts to interpret the Constitution as saying these rights already existed. I think at root the philosophy was, if we make a new law, we are admitting that the Constitution never protected us in the first place. If we go to court, what we're saying is that the federal government and these other people had been violating the Constitution all along, that we always had this right that was denied to us, rather than having to make a new law to give us this right. So the NAACP, as I said, goes the route of the courts. Many court decisions. Many. Just a few to highlight it. In the Gwynn v. United States case in 1915, they brought a case to court in which the court found that those grandfather clauses violated the 14th and 15th Amendments. So there were a number of states, Oklahoma and Maryland, I think, among others, that had written into their constitution that if somebody's grandfather had voted, they were exempt from paying a poll tax or literacy tests. That made it possible for even poor, illiterate whites to vote. But it prevented blacks, so it was aimed clearly at disenfranchising blacks. The court found that the grandfather clause was trying to play a game to get around the Constitution. And therefore they found that the grandfather clauses in those states were unconstitutional. In Smith v. Allwright, which is a 1940s case, the NAACP was behind the suit. Okay, blacks have to be allowed to vote, but in Texas, they tried to prevent them from voting in a Democratic Party primary on the grounds that the Democratic Party is a private organization and they have the right to set their own rules about who can vote and who can't. At the time, if you opened up a private club, you did not have to accept anybody you didn't want to. So if you wanted to open a club that was open only to whites, that was legal. So they said, well, the Democratic Party is a private organization too. We don't have to let blacks vote. And the Supreme Court found that, in fact, they did. Democratic Party may in some sense be a private organization, but its primary elections were administered by the government of Texas. Primaries, you went into a government voting booth, the government set the rules for how you got on the ballot and all of that, and therefore it became a government issue. So blacks couldn't be excluded from a political party or from primaries. And then finally, famously, of course, the most important, Brown v. Board of Education of Topeka, Kansas. 1954 case in which the court finally ruled that there was no such thing as separate but equal. That segregation of the races, separating them out, was inherently unconstitutional because it violated the Equal Protection Clause. You were treating these groups separately, and therefore, by definition, unequally, and therefore you couldn't have a separate white and black school system, a separate, white and black public health office, whatever it was. There were a whole bunch of subsequent decisions to Brown v. Board, including a couple of other cases called Brown v. Board. But they all went down the same line. It was all about busting up the segregation in public accommodation. Let me turn back for just a minute to women. Where were women all through this? Once blacks were freed, once slavery was ended, the women who had been involved with the anti-slavery movement began to turn their attention to other things. This is the reform era, or the progressive era, that you should remember from U.S. history. They turned their attention to things like child labor, where little kids, and really, guys, I hope you got this in U.S. history, 5- and 6-year-old kids were working 12-hour days, 7 days a week, where women were given particularly hazardous duties and hazardous jobs, where workers were put into extremely hazardous conditions with no protection. They also got involved in other aspects of this, most notably prohibition. And I hope you remember from U.S. history, you have to understand the prohibition movement was not viewed as taking liquor away from people. It was viewed as protecting women and children. In the late 1800s and early 20th century, alcohol was, available and rampantly used. There was not really all that much in the way of other kinds of drugs available. There was some opium available and some cocaine available, but they really weren't widely out there. So alcoholism and alcohol abuse covered everything that we consider, covered all the people that today would be involved with it, and all the people who would ever be involved with drugs, and a whole lot more. Alcohol abuse was really quite rampant in the country. And the people who suffered the most were women and children, because the guys would go out and would get, liquored up and come home and would slap the women around and would slap the kids around. Or they'd go out and get liquored up and lose their job. Remember, too, in those days, there was no such thing as unemployment or workers' compensation or anything like that. So if a guy went out and got drunk and lost a day of work, he simply didn't get paid for that day, which meant the family starved. If he got drunk and was fired, there was no unemployment insurance. If he got drunk and was injured, there was no health insurance, no workers' comp. If he got injured on the job, the family just starved. So the people who really suffered the most from alcoholism, who suffered the effects, if you will, of a male alcoholic were the wife and the kids. Well, now, why am I talking about that so much? Because that's why the women's movement and the temperance movement, as it was called, the prohibition movement, were so closely tied up. So in the late 1800s and the early 20th century, the movement to prohibit alcohol and the movement to give women the vote, along with the movement to protect children from child labor and so on, were all tied together. So it's not a surprise that at the same time that prohibition gets passed in 1919, that in 1920 you get the 19th Amendment, which gives women the right to vote. That whole progressivist movement, making society better, cleaning up the mess that we had made of our society, was tied up with the women's movement to right to vote. So they get that at the same time, just about the same time, that prohibition comes along. And if you go back to that era, That's also around the same time that we're starting to put in worker safety laws. That National Consumers League I mentioned there was very into minimum wage laws, maximum hour laws, so you couldn't, you could only work 6 days a week instead of 7. They were fighting for the 12-hour day, in those days. So those are all tied together there. Okay, so Brown v. Board in 1954 was then part of what is sometimes called the civil rights era that you probably know, Martin Luther King and all of that business. I should point out a couple of ideas that you should pay attention to. First is that the federal courts, ordered desegregation of Southern schools. And the Southern states didn't want to go along with it, as you should know from U.S. history. So Dwight Eisenhower, who was a Republican and believed in small government and believed that the federal government should stay out of state business, even though he believed that, sent federal troops in the 1950s into the South to force them to desegregate the schools because, he said, it was a federal court order. And the executive branch has an obligation to carry out the decisions of the judicial branch, and a state doesn't have the right to deny that. So I just point that out to you because you always, in our discussions of government, you always have the separation of powers issue. So the judicial branch is making a decision about what is constitutional and what is not. So a kind of judicial review, a term to know. The executive branch's job is to carry out the law, whether the president likes the law or not. What the law means is determined by the court decision, and therefore the president has to carry it out. And federal law is supreme, the supremacy clause. A state can't simply say, we don't like it, so we're going to opt out of it. So even though Eisenhower, who was not a particularly bad guy, but he was not, his own feelings about race were a little bit complicated. And he certainly believed that the federal government should stay out of state business. He was a small government conservative. Still understood that as the executive, it was his job to enforce federal supreme law as interpreted by a federal court against a state that refused to comply with it. So it's an interesting constitutional moment there. Okay, I just point out a few of these things that I hope you know about. So during the Civil Rights era, which, we were talking about 1950s, 1960s, and even into the early 1970s, you have these various groups. The NAACP, the Urban League, comes along, which is another group advocating on behalf of African Americans. You should know from U.S. history and reading and so on, the SCLC, the Southern Christian Leadership Conference, which was the organization that Martin Luther King headed. People sometimes, who don't know their history get that all confused. King did all of his work as a Baptist minister. And the SCLC was a conference of mostly Baptist ministers, but some other Protestant ministers in the Southern Christian Leadership Conference that worked on behalf of non-discrimination. And as you know, King was very big on nonviolence and on a spiritual basis for what he did. So he said that all human beings, white, black, Catholic, Jew, Protestant, didn't matter, are made in God's image, therefore they should be accorded a certain respect for their human dignity. So on that sort of spiritual basis, he then said, and therefore we refuse to cooperate with discrimination. And so he was very big on nonviolence. You simply don't go along with it. You go to the lunch counter and sit there, even though you're black and it's a white lunch counter, but no matter how many times they punch you, you don't punch back. That was what the SCLC was. And you all know the history of that, I'm sure. SNCC, known at the time as SNCC, is the Student Nonviolent Coordinating Committee. And SNCC was a group of college kids, mostly northern college kids. One of the big places for SNCC was actually the University of Michigan. But it was a lot of kids it was a lot of high school and college kids, so just about your age, who wanted to help in the movement for human rights and human dignity in the South. And so they would go and join the sit-ins. So if you see films of that period, you'll see that you'll have guys like King and, some of these, I wouldn't say older, King was a middle-aged guy, leading this march, and you'll see an awful lot of white teenagers in the group there that are joining them. And that's all northern kids from SNCC that participated in the sit-ins and the freedom rides. And if I can say, with true courage and heroism, a number of SNCC kids were killed for, supporting these blacks as they tried to get equal rights. The Freedom Riders were, the Freedom Riders, again, I'm assuming you know all this from U.S. history, went down on buses. They hired like Greyhound buses and went down and rode along with the protest movements. They were shot at. Their buses were burned. 4 of them were taken out and shot in the middle of the night by a bunch of sheriff's deputies who didn't like these northern kids down there. So the SNCC crowd did some very admirable things. Okay. And I'm just rolling through these again. I'm assuming you've read. Civil Rights Act of 1964 was passed. Actually, John F. Kennedy had been working on it, and he was assassinated in 1963, November 63, which gave Lyndon Johnson, the opportunity. I hate to sort of put it that way, but the people got so caught up in continuing John F. Kennedy's legacy that he had an easy time, if you will, getting the or I shouldn't say that an easy time. He had an easier time than he would have had otherwise getting the Civil Rights Act passed. The Civil Rights Act outlaws discrimination in voting and in public accommodations, meaning public places, public streets, railway stations, restaurants, things that are open and available to the public. It outlaws discrimination based on race, religion, color, country of origin, sex, any of that. The Voting Rights Act of 1965 is a little bit more specific. It outlaws any attempt to diminish the value of the vote of any person. That's not how it's put in the law. I'm putting it to you that way. But what that means is that, for instance, you can't, when you draw voting districts, you can't draw voting districts in such a way that you are trying to split up groups so that they can't get one of their people elected. So if you have a county and you have to divide it into 2 voting districts, for, I don't know, state assembly or member of Congress or something, you can draw the lines, you have to draw the lines, but you cannot base those lines on how do we make sure that in no part the blacks have a majority so that they could get a black guy elected. That sort of thing is outlawed by the Voting Rights Act. Setting up registration systems, if you say that in order to register to vote, you have to come in person to the Board of Elections office. Okay, that's okay unless the Board of Elections office is accessible only by private car. If there's no public transportation, any way to get to it, so that poor people who can't afford a car aren't able to register to vote. And you do little games like that to try to keep people from voting. That's outlawed by the Voting Rights Act. In the same era, in the 1960s, they also passed the Equal Employment Opportunity Commission, which is a federal board agency that if you complain that you are being denied the opportunity to work or you are being discriminated against in getting a job, you can complain to them. It's sort of like bringing a lawsuit. Similarly, the Fair Housing Act. You can't, if you were publicly offering housing, if you advertise that I have an apartment house and I have 10 apartments available in it and I'm trying to rent them, you can say, I will only rent it to people who can afford this much rent. I will only rent it to people who have a good credit history. You can say things like that. You can't say, I will only rent it to white people, or I will only rent it to black people, or I will only rent it to Asian people or something. That's discrimination. I mentioned a couple of other terms that you might not be fully familiar with. Busing. We don't really do busing much anymore, but busing, when it's used in this context, means something specific. It was found in the 60s and 70s that there were a lot of public schools that were all one color. So you'd have a local neighborhood school that was 99% black kids, and another neighborhood school on the other side of town that was 99% white kids. And the thought was that it might be good, and in fact it might be right, to mix those up, because the white school was getting an advantage with whatever, the kids there. You basically had separate education. Even if you wanted to argue it's separate but equal, it's still segregated education. And so attempts were made to set up a busing system. This was done most famously in Boston, where they would take the kids from the black district and put them on a school bus and take them to the white school, and vice versa. As you can guess, this really upset people. Rocks were thrown at these buses. Things got pretty violent there with the busing, what was called the busing crisis. Some of it was downright, straight up racial discrimination. It was just white people who hated black people, and I suppose black people who were upset at having to go to a white school. A lot of it, though, some of it, I should say, was people simply upset that you were taking the kids out of the neighborhood. This is my neighborhood school. Why should they have to go to school across town? Busing did not work. It was a gigantic failure, and just created more problems than it solved. But it forced the courts to think about de jure discrimination and de facto discrimination. De jure, or de jure discrimination, Latin for discrimination de jure, from the law, versus de facto discrimination, discrimination from the fact, or from the thing having been done. And what's the difference? De jure discrimination means that there is a law or policy put into effect, the purpose of which is to discriminate or segregate the races. So you make a law saying only whites can use this water fountain, only blacks can use that water fountain. De facto discrimination is when there is segregation that simply, if you will, happens. It's not intended by a government policy. It's not promoted by a government policy. It just simply takes place. So, you know, if you've ever been in a, I don't know, well, you guys have all been in a grammar school, right? So you're in a co-ed grammar school, and it's the first day of school, right? And everybody runs into the cafeteria for lunch. If you stand there and say, all right, boys, you have to sit on the right, and girls, you have to sit on the left, that's de jure segregation. If, on the other hand, you just let the kids go, you don't say anything, you just open the doors and you let the kids go, you guys know, you've been there, right? What happens? All the boys sit together on one side and all the girls sit together on the other side. And nobody has made a rule about that. It just happens. The courts have found that de jure discrimination violates the Constitution, and the federal government can step in and do something about it. De facto discrimination might be unfortunate, it might be not good, it might be unwise, it might be tragic, but it is not something that the government can do anything about. It's not something that the government can really intervene on. Okay, let's get back to women's rights briefly. Okay, I'm going to continue, guys, because I would like to get this done for you in one lecture, so I'm going to go a little bit longer. Let's talk about women's rights briefly. As the civil rights for African Americans really got ramped up in the 60s, so women began to, it's odd that the women's rights movement began in the abolition movement of the early 1800s and really kind of followed along parallel. And when the black civil rights movement really was achieving its aims in the 60s, women again sort of picked up from that. So in the 60s, you had the National Organization for Women got rolling. It was formed in 1966. Largely, NOW got rolling because the Equal Employment Opportunity Commission that I just talked about was seen as inadequate, that it wasn't really doing the job well enough. You also had around the same time the publication of a book called The Feminine Mystique. Feminine Mystique was by a woman you should probably know by the name of Betty Friedan. Again, I'm assuming you did all this in U.S. history. The Feminine Mystique was really the book that launched a reevaluation of the women's movement. If you look at all of those sitcoms that are on, like, what is that, TV Land or whatever that channel is that has all the 1950s TV shows on it, the Feminine Mystique questioned all of that. The mom whose job is simply to spend all day washing the kitchen floor and making supper and to be supportive of her husband and do her kids' laundry and not to have a career of her own and not to have a life of her own and all of that. The Feminine Mystique was the book that really blew all that apart like a nuclear weapon and launched the women's movement. The women began to break through. And again, I don't know if you've seen this. I'm not particularly promoting these shows, but there was a show that was a big deal until recently called Mad Men, about Madison Avenue, about the advertising business. And if you saw any of that, I was not a big religious follower of it, but I saw, I don't know, maybe 3 episodes. And what I found interesting is they did get the sociology of the period correct. If you went into a business in Manhattan, big office, big advertising agency in the 1950s, and into the 1960s, you would have seen men and women. The women all were secretaries. None of them had any executive positions at all, ever. Wasn't even considered. No matter how good they were, how competent they were, how smart they were. So there was a movement in the 60s to break through all that. The Equal Rights Amendment, the ERA, was proposed that would have defined in the Constitution that the genders have equal rights. It got started in 1972 and has never passed because even though a bunch of states approved it right away, it kind of started to slow down as people questioned whether we really needed this and what was it going to lead to. You know, in the case of men and women, is equality the same thing as sameness? Yeah? Are men and women the same? Excuse me, the same, even if they should be treated equally? And I'm not advocating, for that, but that was what you began to run into. At the same time, other laws were put into place to protect women. So the Equal Pay Act of 1963 say that men and women have to be given equal pay for equal work. I know it may seem, I hope it seems sort of incredible to you guys, but it was quite very much the case that if you hired a guy as, I don't know, a typist, typing on an old typewriter in 1965, if you hired a guy to be a typist, and, you would pay him, pick a number, $50,000 a year, which would have been an enormous amount of money at that time. And if you hired a woman, you'd pay her $30,000 a year. And that was perfectly okay, and it didn't occur to you otherwise. They're doing exactly the same work, exactly the same job, but you simply, you give women less. And part of the argument was, well, the guy is more likely to be a father and a husband, and so he's the breadwinner for the family, and, women aren't really usually the breadwinner for the family. Well, women said, wait a minute, you're not paying me a salary based on what, my family needs, because if that were the case, there's all kinds of things you could say about that. You're paying me based on the work I do, and if the work is worth $50,000 a year for a guy, it's worth $50,000 a year for a woman. So the Equal Pay Act says you cannot discriminate in pay. There are arguments that is still a problem. On a sociological level, on a statistical level, the average woman actually still makes less than the average man does in many professions for the same job. There are modern arguments about that. That have to do with how fast women are promoted, what their longevity on jobs is, and that sort of thing. And again, I'm not taking a position on that. But what is certainly outlawed by the Equal Pay Act is saying, I have this job. The job is teacher, and if you're a guy, I'll pay you $50,000 a year, and if you're a woman, I'll pay you $40,000 a year. That's absolutely illegal. Title VII of the Civil Rights Act protects against sexual discrimination and sexual harassment. So under the Civil Rights Act, under Title, laws are often broken into what are called titles. It's like chapters of the law. Title VII says that women, men and women, are protected from being sexually harassed at the job, and they can sue if they are. And you can't discriminate against somebody simply because of their sex. So you can't say, I only hire women or I only hire men. There has to be some other reason. So if you have two candidates in front of you for a job, and one is a guy and one is a girl, you can't simply pick the guy because you hire guys. There has to be some reason related to the job why candidate A gets it rather than candidate B. Title IX, I hope you are familiar with Title IX. You should be familiar with Title IX of the Educational Act because it affects many of you guys. Title IX, the Educational Amendments of 1972, says that educational institutions cannot discriminate against female students. All right, what does that really mean? What that really means is that, for instance, a college must spend as much on women's sports as it does on men's sports. So if the college is spending $100 million on its football team, it has to find $100 million to spend on its women's sports. It doesn't have to be one team. They can spread it out. This is why a number of colleges actually shut down some of their smaller sports for guys. A few years ago, I won't name the school because I don't want to create an issue, but there's a school that I actually sent a bunch of guys to who were wrestlers, and they got wrestling scholarships. And the school had a football team. They were spending so much on the football team that they didn't have enough to be able to spend the same amount on women's sports and still be able to spend money on wrestling. So they shut down their wrestling program, or they shut down the money that they spent on it. So they couldn't give an athletic scholarship to wrestlers anymore because they were giving so much to the football guys that they didn't have money to also give to wrestlers and then give the same money total to the women's sports. And, you know, I'm sure many of you think that that's terrible and awful and unfair, and why should that be? But, you know, if you're a woman, why should a college spend more on football than they do on women's soccer? You know, if it's ultimately an educational institution, shouldn't they be spending approximately the same amount on all of the kids in the school as individuals to get them educated? So that's the idea of Title IX. If you spend $1 on guys, you have to spend $1 on women, and vice versa. If you have, you know, if it's a school that has a great emphasis on women, and there are colleges that do, you have to give as much to the men's sports as you give to the women's sports. I'll mention a couple of cases here. Reed v. Reed, 1971, which was a case about probate. It was about adoption, actually. And Reed v. Reed found, well, I shouldn't say that. The case really didn't revolve around adoption. It revolved around court appointments. When somebody dies, if they have money left behind, the court will often appoint an administrator whose job is to manage the money and the possessions, to pay off the dead person's debts, to arrange for any kids left behind to be properly adopted, and so on. So the administrator is there to manage the estate, as we say. And Reed v. Reed was a case, I think, out of Oregon, that the law said that men were to be preferred to women as administrators. That was found to be illegal discrimination because they couldn't come up with a rational basis why men would be better at it than women. Similarly, with the case of Craig v. Boren, Craig v. Boren was a case, a 1976 case, that had to, this actually, get this, it was a case out of, I think it was Oklahoma, where there's a thing called 3.2 beer, which is it's alcoholic but lightly alcoholic beer. And the state had a regulation saying you couldn't sell this beer to women if they were under 18 or men if they were under 21. The argument from the state was that men had a higher rate of getting drunk and disorderly, getting arrested for being intoxicated, and driving drunk. So basically, the argument wasn't put quite this way in the case, but the argument was that that a 20-year-old girl was less likely to get into trouble with alcohol than a 20-year-old boy was. And the court found that that was, again, discrimination. Statistical evidence like that was not sufficient to overcome the Equal Protection Clause. U.S. versus Virginia is a more recent case, 1976, and it has to do with Virginia Military Academy, VMI, the Virginia Military Institute, which is sort of the West Point of the South, which was all male. And Virginia offered to set up a duplicate school for women rather than allow women to enroll in VMI. And the court found that, again, separate but equal when in regards to gender is also de facto and de jure discrimination. And so it forced VMI to accept women into its classes. Okay, I guess at this point I should just mention a couple of terms that in your reading I'm sure came up with regard to these cases I just talked about. Minimum rationality test means the governments must give a rational foundation for any distinction that they make. So if they say that we will only accept, only men can be cops, for a while there were no such thing as women cops. The government has to provide a rational foundation for why they are making that distinction between men and women. They can't just say, well, because it's better to have guys as cops. You have to make some kind of a case. And of course, we know that the case was not made for that. Same thing for instance, firefighters. You can't simply say that women can't be firefighters because men are better at being firefighters. What you have to do is provide a rational foundation. And if you can't, there has to be a test. If you create a rational test to be a firefighter, like here's the average weight of an average body, can you pull it across a floor like you'd have to in a fire? If you can, whether you're male or female, you can be a firefighter. If you can't, whether you're male or female, you can't be a firefighter. That would meet the minimum rationality test. Suspect classification is when you are using a classification that triggers the court to look most carefully at what you're doing. So if your classification is we only accept people as firefighters who are able to drag a 200-pound weight, that's not a suspect class. A suspect class would be one that does not appear to have a rational basis for it. So if you say we do not accept as firefighters people who are black or Latino, that would be a suspect classification. Race is by definition, race and gender are suspect classifications. If you're making distinctions solely based on race or class, you better come up with a very good reason why you're doing that. That's what it means to be a suspect classification. Strict scrutiny means that the court is going to take the most careful look at something. When you are trying to take away, it's really used in two situations. If you are attacking, if the government is trying to limit one of the fundamental rights in the Constitution, like freedom of speech, that's subject to strict scrutiny. That is, you have to have a very good and clear reason why you are attempting to do that. And it has to be very convincing to the court that you have a compelling state interest in doing that. In a way that some other thing that is not a fundamental right would not attract that level of examination by the court. Similarly with a suspect classification. If you are classifying people for a job according to their ability to lift a weight, there should be a reason behind it, there should be a rational reason behind it, but that wouldn't attract the strictest scrutiny of the court. If you were saying, we are classifying people for this job based on their race, that's going to attract the strictest scrutiny by the court. Okay, and then just to finish up, a couple of other quick matters. We talked about primarily African Americans and women seeking, first of all, their full actual civil rights, that is, the ability to vote, to serve on juries, and so on, and then seeking true equality that is making them effective, so taking away the hindrances to allowing them to participate fully. Other groups that have been through similar issues, just quickly, you have Latinos, that have sought similar things when it comes to things like representation, school funding, immigrants' rights. American Indians, the American Indians are in a very complicated position legally because the tribes are self-governing. They are considered domestic sovereign entities, which is, to make it simple, they are under the protection of the United States, but they are a self-governing entity within the United States. I just mentioned there a case, Santa Clara Pueblo versus Martinez, which has to do with membership in a tribe, how one defines membership in a tribe. And what was important about the case is that the case was brought in federal court, and the federal court said, we can't decide the case because the tribes have a right to govern themselves. So the federal government cannot make decisions for the tribes or rule on the constitutionality of internal tribal decisions. Asian Americans, there's quite a bit there, but again, the most famous case that you are likely to run into, and you are likely to run into it on the AP, is Korematsu. The Korematsu v. U.S. case, if you remember, after Pearl Harbor was bombed, President Roosevelt signed a series of executive orders. These were not decisions by the Congress. He signed a series of executive orders as commander-in-chief, in which he put a curfew in place specifically and only for Japanese Americans. He ordered Japanese Americans away from the coasts, particularly the West Coast. So if you were Japanese American, you were not allowed to live or be near the coast of California. Ordering them to assemble and then putting them into, we don't like to use the word concentration camp, and it was not a death camp. They were not sent there to be machine gunned or something, but they were put into relocation camps. So, you know, you have these people who were American citizens, American citizens, many of them born in the United States, who had businesses in San Francisco, who had lives in San Francisco, who owned houses on the East Coast, who were forced to take everything they owned, pack it up, and go off to live in one of these camps out in the middle of the western states, on the idea that because they were of a certain ethnic background, they therefore were suspect as being sympathetic to the enemy and could provide them with help if we were invaded. In the Korematsu case, the Supreme Court sided with Roosevelt and said that the curfew was okay, and said that the exclusion order, which said that they cannot live near the coast, was okay. They did not get to the issue of whether they could be placed in these holding camps. The court didn't actually deal with that. They just dealt with the issue of whether they could be removed from the coast, and said that the threat to the United States outweighed any individual right they had as American citizens. To this day, it is a highly controversial case, and there are many who say that it was wrongly decided. We also know that the gay community has been active in pursuing civil rights. The don't ask, don't tell policy in the military, I'm sure you guys are familiar with and have heard of. It used to be automatic. If you were discovered to be gay, if you were discovered by a psychological test or by rumor that somebody else said that you were gay, you were automatically kicked out of the military and charged, actually, with a crime for having joined the military, even though you have gay tendencies. Then there is the don't ask, don't tell policy, which is that as long as you don't make an issue of it, we won't ask you if you're gay, and you can't be discharged just for that. And the military has gotten away from even that now. Romer v. Evans is a case, 1996. The people of Colorado put an amendment into the Colorado state constitution that excluded homosexuality, that is being gay, from protection under anti-discrimination laws. So the people of Colorado wrote into their constitution that if there are any laws that say you can't discriminate because of gender, religion, race, national origin, being gay is not a protected class, which basically said that in Colorado you could make a law discriminating against gays. That's what it did. The Supreme Court in the Romer v. Evans case found that that was unconstitutional under the Equal Protection Clause of the 14th Amendment. So the federal government has the right, again, to step in to see that all citizens have equal protection under the law, and that's a violation of it. And then the ADA, the Americans with Disabilities Act, there's been a lot of litigation about that, but basically it says that the non-discrimination of the Civil Rights Act of 1964 we talked about extends to all of those who suffer from any disability, and that the disabled have to have equal access to public facilities, to employment, and therefore if you are running a public building, it has to be equally accessible to those who are handicapped and those who are not. So you have to put in a ramp, or you have to, your steps can't exceed a certain height, or you have to have an elevator to get to the upper floors, or what have you. Finally, I want to mention two other cases that are worth looking at. What about what's sometimes called reverse discrimination? For years, blacks, for instance, Jews, for instance, even in some institutions, Catholics, were excluded, were not permitted to attend. So, for instance, certain colleges and universities. So a positive attempt, affirmative action, positive action, was introduced as a way to reverse that. So if blacks had been excluded from higher institutions for so long, we would make a positive attempt to include them, to go out of our way to include them until that disparity was evened out. Well, the Bakke case, Regents of University of California versus Bakke, was the first to charge reverse discrimination. And that was a case where Bakke was a white kid who wanted to get into the University of California's medical school and was denied admission, and claimed he was denied admission because black kids who were less qualified were being picked over him. So there was a kind of reverse discrimination against him where black kids were being allowed in with preference over white kids. The court heard the case, and the argument on the other side was that there is an educational value to diversity. That if you have a school, if you are running a university, and all of the kids in the university are the same, they all come from the same background, they're all of the same economic group, they're all the same color, they're all the same, that inhibits their education. Part of the point of a university, they argued, is to mix it up so that kids of different backgrounds and different experiences are sitting next to each other in class and learn from each other. Part of what a university should be doing when it builds a freshman class is providing for that. The court in the Bakke case found, if you will, both ways. It was a 5-4 decision. What it was really was a 4-person decision saying you couldn't have admissions quotas, and a 4-person decision saying you could have admissions quotas. The 9th guy, who was Justice Powell, came down on both sides. He said you can use criteria like racial background as a part of the picture, but you cannot use it with rigid quotas. So you can say, in our medical school class next year, we want to have different color kids, and we hope to get a significant number of black kids and a significant number of Asian kids and white kids. But you can't say, and therefore 20% of the kids will be black, and so we will take the first 20% of them, and 60% of the kids will be white, we'll take the first 60% of them. In other words, race can be a factor, but it can't be the factor. In the Grutter versus Bollinger and the Gratz versus Bollinger cases, both of those were cases related to the University of Michigan. Bollinger was the chancellor of the University of Michigan. The Grutter case, I believe, was the law school case. Guy applied to law school and said that it was discriminatory against him that the law school was taking black kids over white kids. The court found in the Grutter case that what the law school was doing was okay, because they were evaluating each kid on an individual basis. And to get into law school, particularly University of Michigan Law School, which is one of the best in the country, they're very, very picky. They really read through the entire admissions, all of the essays and all the recommendations. They go deeply into the interviews and all of that. So they take a very careful look at each individual kid. Race was a part of what they were looking at. It was one criteria among a whole bunch, and there was no strict quota there. Therefore, because it was one criteria among many, it was okay. You will find that there are other sorts of things like that that colleges do. For instance, if you apply to a college in the Northeast, pick a school. If you're applying to, I don't know, Princeton, they try to get, when they put up their freshman class, they have a lot of New York kids apply. A kid from Iowa or Wyoming might actually have a bit of an advantage because Princeton likes, again, to make their class diverse, not just by race, but by, they want a New York City kid in the dorm across the hall from some kid from a farm in Nebraska. They learn from each other. They talk to each other. They have each other's experiences. And because you have fewer kids from Nebraska and Wyoming applying to Princeton, in theory, they might actually have an advantage. So the racial thing in the Grutter case was sort of like that. It was one criteria among many that they looked at for diversity. And the court said that's okay. The Gratz case was an undergraduate case. And there the college had a more specific quota, or I think they were calling it a target, that they were trying to meet. And there the Supreme Court said, no, that's too specific. There they were giving, I remember, in the Gratz case, the undergraduate case, they were giving a boost. They scored the kids. So when you applied to the University of Michigan, they scored each part of your application. So how you did on the SAT might be 20% of the application. And if you did really well, you got a 19 out of 20. Your interviews would be 20% of the application. And if you did pretty well, you got an 18 out of 20. And they give you an extra 20 points automatically for being of a particular racial group that they were trying to attract. The court said that that was too specific and not individualized enough, and that was no good. So you can, basically, the results of these cases are that you can take things like race or gender or disabled status, national origin, religion, any of that. You could take any of that into account as one criteria among many as you individually evaluate an applicant for a school, but you could not make it an automatic boost or an automatic quota to get in. Okay. Well, I'm going to leave it there. Hopefully that these things were helpful to you guys. I don't know. Please let me know when we come back if this was worthwhile. We have to get through this material. I'm going to have to work faster when we get back in. I hope you took good notes, and that's it. That's the end of your Christmas assignment.